Chapter 5. Having now considered the question of the commercial system as much in detail as the space within which I propose to confine my observations will allow, I proceed to the other part of my subject, the stamp laws. I shall endeavour clearly to explain the operation of these laws on probates of wills, letters of administration, mortgages, conveyances, legacies, life assurance policies, bonds, bills of exchange, apprentice indentures, and advertisements. There are others, but they are of minor importance. First, then, to speak of the stamp duty on probates of wills and letters of administration with a will annexed, a law which applies to the whole of the island of Great Britain, concerning the degree of weight with which it bears on the different orders of society. It will be seen then, by a reference to the Act of Parliament imposing this tax, that the families of persons dying possessed of personal property to amounts varying from 1,000 litre up to 4,000 litre pay to the government, on an average, a duty of 2¼ on the amount of the property left to them, that the successors of individuals dying worth from 5,000 litre up to 10,000 litre pay duty to the amount of but 2% on the property descending to them, that deceased persons' estates, worth from 12,000 litre up to 18,000 litre, are charged with %15 in stamp duty, those worth from 20,000 litre up to 35,000 litre, only LLS, 4%, and those worth from 35,000 litre up to 1,000,000 litre, on an average about 2.8%. Thus does it appear, that as people's means become greater, the proportion they pay of this tax becomes less. But if I were to stop here, I should have done but little to show the unfair method pursued in rating estates for the payment of probate duty. We must examine the Act of Parliament more minutely to see the palpable manner in which the richer portion of the community is favoured by it. For instance, suppose the estate of a deceased person to be worth £2,000. It will be seen by referring to the Stamp Act, that £50 probate duty must be paid on proving the will. But suppose another to be worth £10,000, common sense and common justice, one would think, demand that this estate, being 5 times the amount, pay 5 times as much duty, viz. £250. But no, £200 only is demanded. Here then, supposing the duty on £2,000 to be no more than it ought to be, is clearly a loss to the revenue of £50. But suppose a third estate to be worth £20,000, an everyday circumstance recollect, certainly if £50 is to be levied on £2,000, £500 ought in fairness to be levied on the £20,000. But how stands the case? Look at the Stamp Act, and you will see this £20,000 is only charged with £350. The revenue therefore loses £150. But suppose a fourth estate to be worth £100,000, a very common case. Why is not this £100,000 to be charged with £2,500, if £2,000 is charged with £50, but it is only charged with £1,500? A loss to the revenue therefore takes place of no less a sum than £1,000 from the proportion of taxes which ought to be received from the estate of one individual, if those who are poorer do not pay too much. There is another part of this schedule by which the effects of intestate persons are taxed, and as much fault may be found of it as of the other. The tax is levied most partially. A few words will prove this. Suppose a person to die intestate, worth £1,000 in personal property. His effects would be charged with £45, but suppose another to die worth £7,000, his effects should be charged with what? 7 times as much, I am told, £315. It should be so, but £210 is all that is demanded, £105 too little, if £45 on £1,000 is no more than right. Suppose again, 8 individuals to die intestate, worth respectively, in personal property, 12, 14, 16, 18, 20, 25, 30, and £35,000, assuming £45 to be a just charge on £1,000. The revenue, in consequence of these sums being taxed at a lower rate, would lose no less than £3,475. It is really difficult to imagine upon what principle or method of calculation the framers of these schedules have proceeded, if indeed they have proceeded upon any principle or method at all. To this should be added the fact, that no administration duty whatever is charged on freehold land and houses, so that while the estate of a person of the middling class, who may at any time die and leave to his family a bare provision in personal property, is charged with a very heavy tax in probate duty, the family of a rich landed proprietor, who dies possessed of freehold estates to the amount of perhaps £500,000 or in fact to any amount, however great, is not called upon to pay one farthing in this way. This is fair taxation indeed, wise legislation,